panel is on pre-trial proceedings. This panel is chaired by the Honorable Mr. Justice O'Driscoll. Mr. Justice O'Driscoll was called to the bar of this province in 1955. He juniored for 4 years to the late Arthur Maloney. After that, he practiced in the law firm of O'Driscoll, Kelly, and McRae, three names that will be known to all of us, as each of them has gone on to a distinguished career on the bench. He is a former bencher of the Law Society of Upper Canada and was appointed a judge of the Supreme Court of Ontario in November 1971. To Mr. Justice O'Driscoll's left, to your right, is Mr. Justice Clarke. Mr. Justice Clarke practiced in Orillia for many years and was appointed to the Supreme Court of Ontario in April 1990. With merger, he moved to the Central East region and is now located in Barrie. Of course, he's appointed to the entire region, and ours, the General Division, is an itinerant court. However, he is centered in Barrie. To Mr. Justice O'Driscoll's right, to your left, is John McMahon. John is an assistant Crown Attorney in Scarborough. He was called to the bar in 1983, is one of my contemporaries, joined the Scarborough Crown Attorney's office at that time. He tells me that he is the GD coordinator for Scarborough, which he assures me stands for General Division. We have as well with us Michelle Fuerst, who is seated closest to me. Michelle was called to the bar of this province, and I've lost my notes, but I believe in 1981. She practices with Alan Gold, one of our previous panelists. Her practice, like Alan's, is restricted to criminal law, trial, and appellate advocacy before courts of all levels, including the Supreme Court of Canada. She is a certified specialist in criminal litigation and is currently the chair of the Criminal Justice Section of the Canadian Bar Association. She is the co-author with Mr. Justice Watt of the Tremier's Annual Criminal Code. As well, she teaches for several organizations, including law schools. We have as well Jocelyn Van Overbeek, one of my colleagues at the Crown Law Office Criminal. Jocelyn was called to the bar of this province in 1985 and has engaged in a varied trial and appellate practice since that time. Her appellate practice has included a great number of appearances before the Ontario Court of Appeal, as well as several appearances before the Supreme Court of Canada. Mr. Justice O'Driscoll.
Thank you, Brian. Our assignment this morning, as you see, is pretrial. That covers various aspects, the bail application, change of venue, matters dealing with the charter, and that matter. Just let me say that before we start, if I may, that we have here a set of rules under 482 subsection 1 of the code. Then we hope that this will, together with the forms, will produce uniformity, as Mr. Justice Watt has said, throughout the province. They're comprehensive, concise, clear, and capable of bringing order out of what is often sometimes chaos. We hope that they will obviate what sometimes is ambush on a daily basis. Again, you will no longer have to draw analogies from the civil rules. This is intended to be a one-stop set of rules. I suppose for the judges who are involved, we can say the same as to the lawyers, the same as American Express say, don't leave home without them. I think I'd like to say on behalf of the judiciary, and I think on your behalf, that we all owe a tremendous debt of gratitude to Mr. Justice Watt and to Brian Gover for their, what I call a labor of love. The hours, the days spent in compiling, arranging, rearranging, editing, proofreading, it's just beyond belief the number of hours that have gone into this, and unless it happens some other place, I'd like to say we owe them a round of applause right now for what they've done. As was said earlier by the Chief Justice, this is a new venture for a Superior Court judge in Canada, and I'm sure that the other provinces will be looking at us and watching as we find our way or stumble our way through, depending on what happens. It's a new area for the judges as well as the lawyers, and we are all somewhat familiar with the civil procedure rules, and we can time to time have a peek at those and see whether there's anything we can pick up and learn from them. Like a new model of a car that's just come off the assembly line, undoubtedly there are bugs in the matter, and from the standpoint of the judges, well, if you find something that you think should be remedied, please write us a letter and let us know, and the next meeting of judges it'll be brought up and hopefully it can be rectified. Let's talk about judicial interim release. Michelle, you have a client in the Metro East that has a lot of money and you don't like to go out there too often. You want to get him or her out. What do you need by way of paper to get the client to the courtroom and get the motion on before a judge to hear the order for judicial interim release? Or secondly, your client has been denied bail and you want to have a judicial review. What do you need according to the new rules?
Rule 20 is the rule that you want to look to find the answer to the questions about bail reviews and judicial interim release. And essentially, the paperwork that's required is the paperwork that you're probably already familiar with and probably already using on these kinds of applications. But there are a couple of significant changes to the practice that I want to highlight. First of all, the notice of application, which is dealt with under Rule 20.03, is now to indicate whether or not the accused, the applicant, is to be present on the hearing of the application. If the applicant is indeed to be present, you are to also provide the background documentation so that a judge's order can be obtained to get the accused to court at the time of the hearing of the application. In addition, affidavit material is required, and Rule 20.05 appears to impose a mandatory requirement that you file an affidavit from the applicant, him or herself. And in addition, you're told under Rule 20.05 sub 2 what that affidavit is to contain. For those of you who do appellate work, I think you'll find that the content requirement is very similar to that which the Court of Appeal imposes, so that there is not a lot of difference there. However, in addition, it is indicated that where practicable, an affidavit is to be provided from the prospective surety and from either the current or prospective employer. And those are two additional items which, under present practice, counsel may or may not be filing. So you may want to look at those provisions more closely. I would also suggest to you, though, that Rule 20.05 isn't all-inclusive. In other words, while it tells you what material you A, should, and B, can file, in addition, it doesn't foreclose you from filing additional kinds of materials. For example, some of you may be in the habit on more serious applications of filing affidavits that are really in the nature of character references from family members or friends of the accused. It would appear under 20.05 you can still do that.
Michelle, this Rule 20.05 says that the application shall be accompanied by the applicant is the accused, the affidavit of the applicant. Now, I'm the accused and I say that's contrary to my charter rights. Why should I have to do anything about that? You can't force me to give an affidavit. Why should I have to do that?
John says that's a good question, and I'd have to agree. This is one aspect of the rules that I think some counsel who had a chance to look at earlier drafts did raise some questions about. However, it seems to me that the general practice is, first of all, that on many bail applications, the accused, in fact, has already testified before the provincial court judge, perhaps obviously not very persuasively if a detention order has been made, but generally that's already happened. We know because of the rules of criminal procedure and the rules of evidence that the accused can't be asked about the circumstances of the offense in any event. So I think that one would have difficulty constructing an argument that this rule is contrary to the Charter.
John, what do you look for in this material as it's served on you?
Well, I think the whole idea of this new rule is to make sure all the materials before the court, and some of the things that haven't been in the past, which now are an obligation that you file all transcripts. And if you want to turn to page 37 of the materials, which is Rule 20.05, just to a couple of things that have changed and that we'd look for to ensure they're there. Under 20.05 sub 1 sub D, it says the applicant will have to, where the applicant seeks to review an order earlier made, a transcript of the proceedings on the judicial interim release hearing, as the case may be, and of previous review proceedings, if any, taken before a justice or judge. We always seem to be in a position where if it was a contested bail hearing, the transcript's naturally there, but there's now a specific requirement that if there was a transcript of the proceedings, and I'm thinking of a case where you have a consent bail, you're going to need the transcript according to the rules. And again, something that is now set out, that if there has been a prior bail review, 30 days before or whatever, that's also going to have to be filed. Something additional that we look for now, once these come in, is that there's a duty on the applicant now under E to bring a legible copy of any exhibits capable of reproduction which were filed on the judicial interim release hearing. And I think what that would set out, usually as a matter of course, criminal records are filed as an exhibit to the hearing, and it would seem to be from the rule there's an obligation upon the applicant to bring those to court and have them filed. So you wouldn't want to get stuck in a position where you have everything there and accept such material. I think the other thing that we look for, obviously, is that the Crown, or if we're the respondent, are entitled to file affidavit material that we may have of additional information, and that we would have to serve that upon you. And the last thing that I think we'd look at is, after reviewing the materials from the Crown's point of view, the benefit that is in this rule to defense counsel is 20, this is page 39. If we can just take you to that, it's 20 sub 6, 06 sub 3. The respondent may consent in writing to an order sought upon terms included in a draft order in Form 10A, which is at the back. Where I can see that as a benefit to defense counsel is that if your client wants to vary his bail to visit his mother in Omaha for the month of December, without the necessity of the expense of you attending court for that purpose, the matter can be done by way of a consent. You need not appear, your client need not appear, and it'll save some time. And I think once the rules come into effect, that should save defense counsel on minor variations or on consent releases considerable time.
Thank you. Jocelyn, what do you think of the business of Crown's consenting ahead of time not in an open court to a release of an accused or a variation? Let's take the release of them to start with.
Well, this would be a case where if it was a release at first instance, you're talking about an offense of some gravity.
These rules only apply to the general division, as we heard earlier. So someone is already in custody, they've been denied, and say it's a review or it's a murder. It's the first time up.
Where it's a review proceeding where there's been a detention order made at first instance, I would think that in the absence of an exceptional change in circumstances, the Crown's not likely to be consenting to a release order without the need to appear in court. Similarly, if you're dealing with release at first instance, you're dealing with offenses of gravity, in most cases a murder charge. And again, in those circumstances, I don't think it's likely that the Crown's going to be consenting to release out of court, particularly where you're relying on the affidavits, and the Crown's going to want to, in most circumstances, cross-examine on at least some of those. I would think that the Crown would not have consent forthcoming to proceed with the matter without having had the opportunity to cross-examine. Just on that note, as far as the Crown's obligations when the materials are received, I would just note that because the scheme appears to be that these matters are going to be proceeding largely on the basis of affidavit evidence, the general rules provide that the respondent to these applications does have a right to cross-examine on affidavits, either in advance at the special examiner or before the judge hearing the application. I don't know that defense counsel are going to, as a matter of routine, make the person swearing the affidavits available for you to cross-examine in the absence of an express request that the Crowns want to cross-examine be there. So I think it's incumbent on the Crown, when receiving these applications, to review them to determine which witnesses they're going to want to cross-examine, and to advise defense counsel that they want those people present on the return date of the application for the purposes of cross-examination. Also, if the person the Crown's wishing to cross-examine is the accused, I think the Crown should be reviewing the application as it comes in to find out whether defense counsel has requested that the accused be present, because if defense counsel hasn't made that request and supplied the appropriate supporting materials, there will not be a judge's order issued to have the person brought to court. And the Crown can apply pursuant to Rule 23 for a judge's order to have the person brought to court. So when the Crown is wanting to cross-examine witnesses, the Crown has an affirmative obligation to ensure that those witnesses are available in court to be cross-examined, either by advising defense counsel or by securing a judge's order if the defense haven't done so.
So Justice Clarke, how do you see this affecting the role of the judge hearing reviews or initial applications such as in murder trials? What's it going to do for the judge?
I think that the best that can be said for it is that it's going to give the judge an opportunity to review the material before you start the proceeding. The affidavits in support, any prior proceedings, any exhibits filed that Michelle has referred to will be of considerable assistance to the judge who's going to have to decide the matter. If either the Crown or the defense, and I can imagine many circumstances where the defense will want to, under Rule 23, apply to have their client there to be examined and cross-examined, it seems to me that it may well be the concluding factor that assists the defense in the release of his or her client. The other aspect of it is that I would expect and I would hope, contrary to the view that's just been expressed, that with proper and full and adequate material, it would bring upon more consent releases and alleviate very busy schedules on Monday mornings.
I see in, was it 21041A and other places, the expression an affidavit by or on behalf of the appellant, applicant. Now, are we going to continue to have affidavits by secretaries who really don't know too much about the whole thing, or are we going to get real affidavits? Michelle?
Well, I think the reality is that for some of these applications, and bail reviews are obviously one of them, if you actually want to get your client out, it's not going to be good enough to provide affidavits from secretaries and law clerks and law students and so on. On the other hand, if you're dealing with something like a request for an adjournment, my own view is that In many instances, the basis for the application is really not in contention. For example, the fact that counsel is counsel on another matter that is continuing on the date set for the particular proceeding. Generally speaking, that really isn't an issue as between the parties, and I think in those circumstances it will remain appropriate for the affidavit to be filed by another member of the lawyer's office so that the lawyer, him or herself, is still able, in fact, to appear on the application to seek the adjournment.
Jocelyn, do you need a factum on an application for judicial review, interim review?
No, there's
Or
no
release?
fact. There, according to Rule 20.05 sub 4, there is no factum required on these applications.
Mr. McMahon, the accused has served and filed a real zinger of an affidavit that you really want to cross-examine on, and the counsel decides in his or her wisdom not to have the accused present at the bail review. What do you do?
Well, I think as Jocelyn mentioned a few minutes ago, there's provisions under the new Rule 23 to require the attendance of an accused and how you'd go about doing the application and the affidavit, and it's pretty straightforward. But it's quite clear that the Crown has an absolute right, or the opposing party, to cross-examine on an affidavit relied upon, and quite clearly that's what would be done. There was talk this morning about the possibility on any affidavit of going before a special examiner. I would think it would be unrealistic in regard to bail matters, because especially with an accused, you'd want the presiding justice to be in a position to assess the credibility of that accused firsthand. So if they don't bring the accused, that would be the position the Crown would take.
Jocelyn, if the defense counsel wants his client who is in custody to be there at the hearing, whose duty is it to see that the proper order is obtained and that the person is present?
It would be the obligation of defense counsel, and the steps to be followed are set out in Rule 20.03, commencing with subsection 2, which indicates that the notice of application in Form 1 shall also state whether the accused is to be present. So you should be addressing your minds when you're filing the notice of application to whether you want your client to be present at the application, and that will have to be set out in the notice of application in Form 1. If you want your client to be present, subsection 2 goes on to indicate that the notice of application has to be accompanied by an affidavit, which sets out certain particulars relating to the client's incarceration and who's going to be bringing him to court and the like. You will also have to file with that notice of application and affidavit a draft order in Form 13A, and this is one of the fill-in-the-blanks type forms that you've been provided with. And then once all of those materials have been filed, the section goes on to indicate that a judge may grant an order that the accused be present at the hearing, ex parte and without the attendance of counsel. So all of those steps will be required right when the application is initiated to ensure that the prisoner is brought to court.
There's just one logistical problem I think we should raise, is that when you do up your application, your affidavit in support, and your Form 13 to get your guy there, the rules of service indicate that you serve the Crown at least 2 clear days before and the court 1 day before. The only concern I think we have to look at logistically is if the judge gets the Form 13, i.e. the order to get your guy there, and he's only got it 1 day before the hearing, there may be in certain jurisdictions practical problems with the police complying with getting the fellow there on such short notice. And it may be, until that can be worked out, a good idea to ensure that there's enough time between you filing the documentation to the time of the actual hearing, more than 1 day, so that won't arise.
To Justice Clarke, what are there logistic problems that you see that are created by these rules for outside of Metropolitan Toronto?
Yes, there are. Certainly in the Central East region, and I know the Northeast region, it because somebody is to be tried in Newmarket, for example, there's no real assurance if they're held in custody that they will in fact be within 30 or 40 miles of Newmarket. I know that the same applies to Thunder Bay and Kenora and places of that nature. You may well find, as John has pointed out, that your client is, to use a local example that frequently occurs, down at Metro West, and you have an application for a review or an interim release in Barrie. The logistic problems are significant, and you should allow sufficient time to get it done, and the response from the persons responsible for bringing the accused to the courthouse will simply be that we cannot do it in the time set out. In fact, I've seen recently in our jurisdiction, they have a stamp that they simply stamp on the return of the material. So that's how common it's become.
Do the people in the Metro West, Metro East still take the position that if he or she is incarcerated here, it's within metropolitan Toronto, even though the trial is to take place in Lindsay, and that's where it's all about, and for security reasons they're down here, and the automatic review has to take place in Toronto? Do they still do that, John?
The only time the automatic 90, I think we're talking about the 90-day review. It seems to me that the 90-day review, just from the practical experience I have, goes in the jurisdiction where the accused actually is going to trial. So a 90-day review, just because of bed shortage or whatever, if he's shipped to Sudbury, he will have his 90-day review in metropolitan Toronto if that's where the offense took place and that's where he's going to be tried, as opposed to being done in Sudbury. That's just a general practice that it seems to have developed, at least in metropolitan Toronto.
All right. Let's move on then, if we could, to adjournments, which are dealt with in Rule 26. Jocelyn, maybe you'd start this one off. There's been a trial date set 3 months ago, and it's all ready to go, and the chief crown witness has just had a heart attack. What do you do?
You pull out Rule 26, which gives you the code of procedure for applications for adjournment. You should note that it applies to applications for an adjournment after a date's been fixed for trial, and the rule requires that the application be brought to a judge of the court in the county or district where the trial is to take place. The timing requirements in this rule are designed to ensure that the application is brought sufficiently in advance of trial, that the court and witnesses are inconvenienced as little as possible. Rule 26.03 requires that the notice of application under the rule has to be served at least 15 days before the date fixed for the hearing of the application, and the hearing of the application shall be not less than 10 days prior to the date fixed for trial. Once the materials have been filed, and again it's a notice of application in Form 1, which is the general notice of application, the applicant will also have to file an affidavit setting out the information required to determine the application, and that includes the particulars of the indictment, the particulars of any prior applications for adjournments, a full statement of all of the facts material to the application, and a statement of the date or dates to which it's proposed to adjourn the matter for trial. So some thought has to be given to the length of the adjournment sought as well. This is an application that doesn't require a factum or a record to be filed. And again, as with all of these pretrial applications, if you can secure the consent of the respondent in writing, the matter may be dealt with in chambers without the attendance of counsel. That's the procedure that's to be followed according to the rules.
Michelle, what are you going to do with that application? Are you going to consent under 2606, or are you going to say, no, I want to argue it out in the courtroom, or what's your position going to be?
I think it depends on whether or not I want to continue to practice at all successfully in that jurisdiction. I really can't imagine vehemently opposing an application brought by the Crown on the basis of the serious illness of the investigating officer. However, I do think it's important, in light of what the case law has told us about Section 11B of the Charter, that one at least put the position on the record that, as defense counsel, you were certainly prepared to proceed on the date set for trial, and that you understand that the particular circumstances require the Crown to bring the application, but at least do something to indicate in some way that it's your wish that the trial proceed on the date originally set, although you're acknowledging the realities of the situation.
Mr. Justice Clarke, you are the judge and you see this consent in writing. It all looks very nice, but you happened to have a trial last week in which this same witness looked very, very healthy. What are you going to do with this consent?
Well, I'm certainly going to make some inquiries, and what I was going to add is that if anybody was in a position to make an application of this nature, one of the factors that is not set out in the rule that would be a considerable influence upon me is if the applicant has inquired of the regional trial coordinator or the trial coordinator in the center in which the trial is to be held, that there is time available some 4 or 5 weeks down the road. I can tell you that in Central East, if Jocelyn was to bring this application before me on a 5 or 6 week murder trial, it likely would not be able to be scheduled for about 7 months. So you would look at it very, very carefully, even if there was a consent.
What, John, what does this do with the situation where the defense counsel on Friday gets a call or something and the case that he or she is supposed to have been arguing in the Court of Appeal next month has been brought forward to Monday, and they're caught looking and they can't go on with this trial and there's no time to fulfill the rules? What do you do? What position do you take?
I think there's the general rule, I think it's Rule 202, that clearly talks about that they can be abrogated in certain circumstances. That's clearly a case where something has come up at the last moment. But I think what's clear from this rule that, and it's set out that you have to serve the other side at least 15 days ahead of time usually. And I think what that means is if you've got your reason for adjournment, you know about it 30 days before and you don't raise it till trial date, in light of the rule, I don't think you're going to be successful. But if it's something that's come up at the last moment, naturally there have to be provisions to seek an adjournment, and I guess that would be done hopefully still with by following the proper notice of application if you have 2 or 3 days to do it in. And if you don't, clearly at least notify the other party and bring it up with the trial judge on the day of trial.
Anything else to deal with?
I'd just like to add that I think there will be a lot of debate about the central phrase in Rule 2602, after the matters giving rise thereto have arisen.
That's like the one on the Ontario Security Commission when it first came to their notice. That's sort of
That's right.
All right. Now, the service on Rule 26, Michelle, where do you serve these materials that the Crown has put together? Are you prepared to accept service of them? If you're the solicitor of record, do you have any choice?
Well, I think in light of what was said on the previous panel, if you're solicitor of record, no, you probably don't have any choice. I think the practice of many defense counsel in reality, again, is that indeed we do accept service on behalf of our clients for, among other things, the reason that Alan Gold had suggested earlier, which is that it avoids contact between the investigating officers and our client. It also, I think, is fair to point out, avoids scenarios where the client is served and conveniently neglects to bring the documentation to his or her counsel's attention, and the necessary date to do something or other, including appearing in court on the application, has passed by the time you as counsel find out about it. So I think that from defense counsel's point of view, the preferable procedure is to accept service on behalf of your client.
Jocelyn, as a matter of interest, if the Attorney General's Department wants to serve a defense counsel of record. How often is the fax machine used these days to do that?
Probably 99% of the time now. The practical reality is that it's difficult to have people running around serving offices. It's not terribly efficient. The fax machine is a lot easier. And the other practical reality is now that the fax machine is there, it makes it possible to leave things until the last minute, and so it has to be used and there's no choice.
I thought Crowns always did things ahead of time. I found it. All right, let's turn now, if we may, to Rule 28, the pre-hearing conference. And this, as you know, is tied to Section 625, subsection 1 of the Criminal Code, and the forms are in the back, 17 and 18, the pretrial conference forms. One's the long form, which is basically used for homicides, and the other is used for the usual criminal case. Now, Mr. Justice Clarke, what's new about the Rule 28 compared to the way pretrials have been done on the basis so far, where each and every case that was scheduled to be heard by a jury had to be pretrial? What's new about this?
There are a number of factors in the rule that are new. The Rule 2802, subsection 1, provides that the prosecutor and counsel for the accused, each fully briefed in respect to the issues, shall be present. And it says shall be present. It is, I think, going to be the experience that will, for the most part, be rather rigidly enforced. The rule provides as well that the forms, either the short form or the long form, depending on the nature of the matter that you're dealing with, subsection 3 of 2802 provides that the defense and the Crown shall jointly complete a draft of the pre-hearing conference form. That, I would hope, will bring about some consensus and agreement as to at least what the issues are, with a view to narrowing the issues. The specifics of the inquiries that are to be made are set out in Rule 2803, and as you can see from the enumerated portions that are set out on page 76 over to 77, the specifics are indeed that specific, so that I would expect that no longer will there be a pro forma pretrial conference. I can assure you that we are doing everything in our region to see that we have useful and full pretrial conferences, and to have counsel come in and say, I can't get instructions, it's going to be a trial, expect to move on, it's not going to be sufficient. We are going to want to know the constitutional issues, the admissibility of evidence issues, and other such matters that are set out in Rule 28.03.
John McMahon, what's the general position of the Crown with regard to the people they send to pretrials?
I think Rule 28 makes sure, or is going to be of a tremendous advantage to the whole system. And what it ensures is that the people that go there, be it Crown or defense, have to be fully briefed and fully prepared, because in the past, as Mr. Justice Clarke indicated, they were sort of pro forma, where defense counsel was busy, so they'd send someone as their agent, or the Crown who was assigned wasn't the Crown there, and there could be no fruitful discussions. What it's clear from the rule is that on every pretrial that's heard, the Crown attorney that is going to be there should be knowledgeable about the file, completely briefed, and be prepared to make whatever decisions have to be made at that point, and be in a position to either negotiate a resolution or narrow the issues. And I think the same is going to be held for defense counsel. The other thing that's important about the rule that's going to bring the parties together is 2802 sub 2 that says a judge may require that the accused, represented by counsel, be available for consultation with counsel in respect of matters to be considered at the pre-hearing conference, and that an investigating officer shall be available for consultation with the prosecutor. And from our point of view, it's an excellent idea because it's going to force everybody that's going to have to make the decisions to be around for consultation so that things can be done properly. And I think the last thing I'd like to say, because from our point, at least from my personal point of view, it's going to help out considerably in reducing backlog, is going to be that the Crown and the defense, prior to going into that room with the judge, are going to have filled out either the long form or the short form. So they're going to have, if we could call it a pre-trial meeting. So at least people have discussed it before they go in.
Michelle, 2802 subsection 2, John has just read, says that the judge may require that an accused represented by counsel be available and for consultation, and it goes on to say that investigating officers shall be available. What's your position with regard to, first of all, do you say the accused has to be in there?
I don't think the accused has to be in there in the sense of being part of the pretrial conference with the judge. However, I do like the idea personally that the accused be in the courthouse, because often I've found that that can work to the advantage of the defense. For example, in a case where you know that your client may well be inclined to enter a plea of guilty, it's a matter of negotiating with the Crown to get to a level where that you feel the sentence that's being proposed by the Crown is a reasonable one, and you're waiting for the right judge, so to speak, to come along. If all of that happens to come together at the time of the pretrial, it's really a shame if, because the accused isn't available or isn't there that day, that you sort of lose the impetus of the moment and you perhaps lose an opportunity to be able to plead the client guilty in front of a judge who you know is going to impose a sentence that you think is within the proper range. So personally, I like the suggestion that the accused should be available in the sense of actually being present at the courthouse. And it always struck me that so many jurisdictions outside of Toronto used to require that the accused be available on the date that was set for the pretrial, and that until quite recently was not a requirement in Toronto, that there didn't seem to be a clear-cut reason for the distinction.
Just learned something I never knew before, that lawyers judge shop. I never knew that before.
Notice I didn't use that phrase, though.
Jocelyn, what, from your perspective, what do you see in the rules with regard to pretrials? Anything that's going to affect your trials that you do, or from 720?
I don't think it's going to affect the trials that we do that significantly, just because they tend to be trials that take a lengthy period of time, where we're often conducting several pretrial hearings and trying to resolve issues. I think the rules codify, though, in fact, what the practice has been. I don't think it's going to change our practice in any substantial way.
Mr. Justice Clarke, if you're going to do a pretrial, let's say it's a complicated robbery, or it's a homicide, what do you like to have before it starts so that you'll know what they're talking about when they arrive?
I like to have the court file. If there has been a full preliminary hearing, I prefer to have the transcripts, because I will take the opportunity to review the transcripts of a preliminary hearing. I would like to have copies of any statements of parties that are going to be in issue, and I would like a description of the exhibits that are going to be in issue, whether it be from the Center of Forensic Science or whatever, particularly as to the evidentiary aspects of the exhibits. I certainly want counsel there who at least know as much as I then know about the particular file. And I can assure you that if it's not the case, I will make whatever convenient arrangement is sensible to allow counsel to get themselves up to speed and continue the pretrial. I see one or two here who have sat with me until 7:30 or 8:30 at night in Lindsay and Peterborough in order to accomplish that, and those are the types of things that I want to know about. I'm glad that judge shopping has now ceased now that I'm where I am.
What, Michelle, what do you say about this business of defense counsel supposed to get together with the prosecutor and fill out this pretrial report conference, Form 17 or 18? You say, look, I'm going to exercise my rights for the accused, and I'm not going to divulge anything.
Well, I think that in this day and age, especially in a case where there's been a preliminary inquiry, it doesn't make a lot of sense for defense counsel to take that position. First of all, if Crown counsel hasn't sort of figured out from your cross-examination at the time of the preliminary inquiry and from the material in the Crown brief where the potential scope for a defense lies, then you've probably got a Crown counsel who is either very inexperienced or for whatever reason not really on the ball. So I don't think that there's a lot of tactical advantage to be gained anymore by defense counsel trying to play the game of, well, I don't have to tell you anything. And it seems to me that most of the areas that are covered by the pretrial conference report are discussed in a general as opposed to a specific way, so that you're not going to feel that you're being tied down, for example, to committing yourself to saying you're going to be calling a particular witness on a particular issue or anything of that nature, which might start to look somewhat more objectionable from a defense perspective. So, again, my own feeling is that defense counsel has everything to gain from participating in the process and really not much to lose.
Mr. Justice Clarke, you were the pretrial judge. Is there any possibility or is there any fear that you might be the trial judge?
No. As far as I'm aware, certainly in our region, and even with consent of counsel, I would think, unless it was a very straightforward matter, that the pretrial judge will not, certainly ought not to be the trial judge unless in the most exceptional circumstances.
At the end of the pretrial, you've gone through it all, and then you get to the bottom line, and they say, well, we've had a discussion. And you say, that's very nice. And they say, yes, we want to plead guilty to manslaughter, and we've got a suggested range, and so forth and so on. You say, that's interesting. And they say, you say, when do you want to put it on? And they say to you, when are you available? What do you do with that?
I open my closet that's part of my chambers, put on my gown, and we go in and do it. I find that concluded pretrials in that manner have a tendency to dissipate with time. And I would like to indicate, and I know that the view is different in some quarters, I indicate rather clearly what my position will be if the matter is disposed of then. And I can tell you that I think that most judges give some considerable consideration these days in the pressure of time. Some consideration is given in the ultimate result to a plea having been taken at a pretrial.
John, what do you ever gone to a second pretrial in the same case?
I think a lot of times it's an excellent idea. If the players and parties aren't that far apart and you're in a position where a second pretrial is required, the provisions of the new rules indicate there can be, and it's my view that as opposed to doing another 2 weeks of trial, if both parties agree that maybe it would be in the best interest of all to have another pretrial, obviously not before the trial judge, but before someone else, I think it's an excellent idea. And if the judiciary is available for doing such a pretrials, it may resolve matters that would otherwise not be resolved.
just while I have you on the topic, what do you see as a Crown prosecutor as a time allotment for a pretrial? I think it's probably more or less uniform that for homicides, usually an hour is set aside. What about non-homicides?
When we were discussing this in preparation for the panel, there's, at least in metropolitan Toronto, there's growing up a practice that they be scheduled for every 15 minutes. And what we're attempting to do is reschedule pretrials that are going to take longer. You can have a major holdup squad case that's going to go on forever, and that it may require additional time. And I think both Crown and Defense have an obligation to when scheduling these matters, to say that, listen, we're not going to be able to discuss all the issues in 15 minutes. And I think a pretrial should take as long as is necessary to make sure it is covered thoroughly. And I think a lot of times, other than the murder-manslaughter situation, not enough time is scheduled for them, and there seems to be feeling constraint by both the judge and counsel that we've only got 15 minutes, so let's bang something through. And I think we should all look at, and defense counsel have an obligation to say, look, we want to sit down and talk about it, but it's going to take a lot more than 15 minutes.
Michelle, what about the timing of the pretrial at the attendance? Do you think it's the farther away from the trial, or the closer to the trial, or somewhere in between is the optimum time?
Well, I know some people are of the view that the closer you get to the courtroom door opening on the day of trial, the more likely it is that the accused is going to agree to enter a plea of guilty. But again, I think that if you can arrange to have a pretrial shortly after the preliminary inquiry has been completed, when the nature of the evidence and the issues in the case are still fresh in counsel's mind, that may well be as good a time as any. And as well, obviously, if it's a case that is capable of resolution, it frees up the resources of judges in the General Division Court at that much of an earlier stage.
Jocelyn, if you have a long case from 720 that's going to go on forever, what do you find is the best for the pretrial? Early or late or somewhere in between, or have several of them, or what?
It's been my experience that there's generally several of them, and they sort of evolve as the issues evolve. It's helpful early on to determine whether the matter's capable of resolution. If it's determined that it's not capable of resolution, then especially in cases where you have a substantial amount of documentary evidence, or perhaps facts that really aren't in dispute, it can be of assistance to attend on a number of occasions to obtain the assistance of a judge to hammer out those kinds of issues.
All right, let's move on to the constitutional issues in Rule 27. You think you have a good ask-off application. What do you need paper-wise to put it before the judge, Michelle?
Rule 27 is a rule that deals with constitutional issues, and you'll notice that, as Justice O'Driscoll has pointed out, it applies in particular in cases where you're going to be seeking a stay of proceedings under Section 24(1) of the Charter, for example, in an ask-off situation. What you're going to have to file in this case is something called a Notice of Application and Constitutional Issue, which is provided for in Rule 27.03, and in the format of Form 5 in your materials. And in the case of an ask-off application, as opposed to an application where you're seeking to strike down a section of legislation, you will be required to serve the office, the Crown office, which has carriage of the prosecution of the particular case. There is also, pursuant to Rule 27.05, Subrule 4 and Subrule 5, a requirement that the parties each prepare an application record and a factum. So this is one of those fairly limited situations which the last panel referred to, where counsel will be required to prepare both a record and a factum.
Now, if you're bringing one of these applications and John McMahon is the trial counsel, do you serve him or do you serve Jocelyn with it?
It appears to contemplate, if you're speaking in terms of an ASCOV application, that I serve John and his office, he being the prosecutor who has carriage of the matter, and his office being the office that has carriage of the matter. And you should just notice that that's distinct from those instances where what you are doing is seeking to strike down either a statutory provision or a rule of law, because in those instances you're going to be required under Rule 27.04 and following to file a number of different offices, including the Constitutional Law Office at 720 Bay and including the Office of the Federal Crown.
Jocelyn, you receive one of these applications. You read it over. What's your next move?
In these cases, the respondent has the opportunity to file any other affidavit material if there are additional facts that should be before the court that the applicant hasn't included with their materials. The respondent is entitled to file an affidavit including those facts. As well, pursuant to the general rules, the respondent's entitled to file a respondent's record if the record filed by the applicant is not complete. And finally, as Michelle noted, the parties are going to be expected to file factums in these materials or in these applications, and I'd be preparing to work on one of those as well.
Mr. Justice Clarke, somebody pleaded guilty unexpectedly, and you are asked to take one of these applications, but somebody else has been designated as the trial judge. What's your position?
If it was an application under 11B, I would deal with it. If it wasn't, I would adjourn it to the trial judge. I should tell you that I am pleased to see the rule, because last week in one of our smaller centers I dealt with a handwritten in-person application on a constitutional issue in regard to one of the weapons sections in the criminal code, and the grounds for the application was, it stinks.
The application or the law?
All of it.
All right. When do you see these applications coming forward? I'm speaking time-wise. Is it going to be a month before the trial, or a week, or is somebody going to make them returnable for the trial judge as a rule, or where do you see them coming from? Michelle, which would you think they're going to be?
Well, if you look at Rule 27.04, sub 1, it would appear that you have to give notice under Section 27 or Rule 27 not less than 15 days before the trial proceedings commence, so that you're going to have served the Crown no less than 15 days before the scheduled trial date. And as well, it appears that you have to have filed your material with the court office at least 7 days before the hearing date of the application. So you're going to be bound by the time strictures of Rule 27 unless you can convince a judge, as was indicated earlier this morning, to abridge the time limits for you.
All right, let's just move on then, if we may. We have a few minutes left. There's something new in Rule 21 that catches everyone's eye. The release of exhibits. With all our talk of DNA these days, John, what's new in Rule 21?
Well, as everybody knows, what we're talking about here is the release of exhibits. And I think defense counsel should look at this rule very seriously if you're going to bring such an application, because it used to be just file a notice of application, come to court, and either just advise the judge, look, I need this for X, Y, and Z, and the Crown would consent, and that would be the end of it. Now, not only do you need the supporting affidavit, but you need an affidavit of the proposed examiner, your expert. Now, And that's set out just so we can look at it. It's on page 42 of the materials. 2104 sub 3, the affidavit of the person or an authorized representative of the agency whom it is proposed shall conduct the test. Now, that's going to give the Crown notice of your proposed expert, and a lot of defense counsel are going to have to think seriously about that. But from my point of view, what makes it even a little more interesting is if we look under 3 and you go down to F, in his affidavit or her affidavit, a statement of whether the examiner, testing agency, or applicant will permit attendance by duly qualified representatives of the respondent at or during the testing, or furnishing the result thereof to such persons. That's obviously going to make defense counsel have to seriously consider how you're going to go about that, and how in the affidavit of your examiner you're going to word that. Because I guess strategically, on one hand, you're of the view that obviously if it comes back and supports the Crown's view or the Crown's expert, you'd rather the Crown not know that and you just bury it. But it is going to require, I think to some extent, a change in the way experts come to court, and there'll be less sort of, as somebody mentioned earlier today, trial by ambush in regard to an expert. I would suggest that is the main material change. There's also clearly in the affidavit setting out how to protect the integrity of the exhibit and how it's going to be dealt with. But that would be the material change I'd see from that new rule.
Jocelyn, under 2105, it says the respondent, I assume that's the Crown, may consent in writing to the order sought upon terms included in a draft order, and a judge may grant such order without the attendance of counsel. When would you see yourself consenting to such an order?
I want to make sure that the materials filed by the applicant are complete and do comply with the rules as required. It's one of the advantages to having such detailed rules prescribing what is to be contained in the applicant's materials, that it will permit the Crown to make an informed decision. Obviously, in a case where the materials establish that the provisions for protecting the integrity of the exhibit are adequate and they're willing to have the Crown's expert present and all that kind of thing, I would think that a consent would be forthcoming.
Justice Clarke, if it were a bookmaking case and the exhibit was flash paper, would you give the order?
I doubt it.
All right. One last before we finish, and that's the change of venue. That's Rule 22. This was mentioned earlier this morning by Mr. Gold, I believe, and it sets out in some detail what's needed. Michelle, if you had an application for a change of venue because of adverse publicity and the trial was to take place in Lindsay, where would you bring your motion?
Under Rule 22.02, you can bring your application in any court in the county or the district or the region where the trial is to be held. So by inclusion of region, it would appear to give counsel much broader scope to try to bring the application somewhere other than the precise location where the trial is going to take place, which for the reason which was pointed out earlier this morning, particularly in smaller jurisdictions, would appear to be a very wise move. So I would attempt to bring it in a judicial center somewhere in the same region as Lindsay and as far away from Lindsay as was possible geographically.
John, what would you look for in one of these applications as you read over the material?
Well, obviously, you have to look at the grounds, and I think usually the grounds we're looking at are publicity. Now, clearly practicing in Metropolitan Toronto, we don't usually have that problem because of the size of Metropolitan Toronto, but set out in the rules of the affidavit on behalf of the applicant, it's quite clear that in the circumstances there's rather detailed information that has to be provided for the court to make the consideration, and I ensure that it was complied with. And the other matter is, in this particular area, is that you're going to need a factum. And clearly, obviously, the respondent will have to return or file a factum as well. So it is a detailed application where all the cards are on the table before we go to court. And I think that's going to be a positive step.
Again, Jocelyn, 2206 provides that there may be a consent in writing to the order sought. Where do you see yourself consenting to such an order?
Again, where it's a case where were the application to be heard in open court, the result would be a foregone conclusion, and that it would be in the interest of justice to have the change of venue. I think the consent is appropriate. I note that the consent in writing, as with most of them, still leaves a residual discretion to the judge hearing the motion for the change of venue to determine whether, notwithstanding the consent, it's going to be granted. One of the other things that has to be provided by the applicant is some sort of proposal as to the jurisdiction in which the new venue of the trial be held. I think that it may be a situation where, because of court administration and scheduling problems, that the judge may want to retain some discretion, notwithstanding the fact that the change of venues on consent as to where the trials move to.
Mr. Justice Clarke, how do you see this new rule affecting what you have to do with changes of venue?
I don't think the new rule is significantly different than the current practice, although I see the provision that Jocelyn refers to proposing a location for the trial if it's to be moved. I can tell you that in most regions, the judges who are hearing these matters will make every effort to see that if a trial should be moved, it be moved to another location within the region. Certainly, Central East is broad enough to move a trial from Whitby to Bracebridge unless it's one of significant publicity, as the recent one that was moved to Napanee. But most often, the regions are sufficiently broad and sufficiently isolated from media attention to allow a trial to be moved within the region. And every effort will be made to see that that is accomplished, because it avoids a lot of difficulties associated with exchanging judges from other regions and having to fill in for their scheduling problems and things of that nature. I know that when I have suggested most recently on 2 occasions that a change of venue seemed to have some merit, and that I would propose moving it from Whitby to Bracebridge, the application was withdrawn. I don't know why.
All right. I just add one thing. If you're going to bring an application for change of venue, be sure and ask the judge for a non-publication order, or otherwise it may all be for naught, especially if you lose it. We have a couple of questions. We have a minute or so. Why is the motion application for severance of the accused or severance of counts not dealt with in these rules? Shouldn't such issues be resolved before trial, or should we give notice of such motions and have them returnable on the first trial date to ensure only trial judge deals with these issues? Another one? All right. We didn't do a very good job. We got all kinds of questions. Michelle, what do you say to that one?
The case law indicates that those kinds of motions for severance of accused or for counts are applications that have to be dealt with by the trial judge. So, as was indicated earlier this morning, these rules are intended to apply to proceedings prior to the trial judge becoming involved. So, I would suggest 2 things. One, that at the time of the pretrial conference, you indicate that there will be an application for severance of counts or severance of accused. And secondly, yes, I would agree with the suggestion that you give notice, file notice in advance of your intention to make such an application on the first day of your appearance for the trial proceedings.
Given some defense counsel practice outside of downtown Toronto area, the area of the general level court, could a system be set up for counsel to be able to order a copy of the indictment via facsimile and receive it via facsimile so that we can get copies of the indictment quickly and prepare possible trial issues and issues re sufficiency of the indictment prior to attending for the pretrial conference, etc.? Any reason that defense counsel can't get a copy of the indictment if they ask the Crown for it? Or somebody
do that. As far as I'm aware, unless there's a problem in some particular jurisdiction, but in a number of cases I've obtained informations, copies of bail orders and recognizances and indictments by fax.
Just makes perfect sense that it's done that way. I think it's the logistical thing of having people to fax things and whatever, but it seems to save defense counsel time, and I don't see a problem with it if there are the logistical resources to fax the stuff out.
what happens if they turn the fax off at 2:30 in the afternoon?
Well, being civil servants, they probably do, but if it's still working, I don't see a problem with faxing it out.
Another question, Rule 612. Are we not in danger of becoming civil-orientated and in danger of ignoring the rules of natural justice in making it the rule to give all evidence by affidavits and only the exception to have viva voce evidence heard on the application? Jocelyn?
Well, I don't know that the rules require that evidence be given by way of affidavit. A part where there are the rules specifically require an affidavit from the applicant. In those situations where it is appropriate to call viva voce evidence, there's still a discretion in the judge to hear viva voce evidence. And I don't foresee a situation where that's appropriate, that a judge would withhold his leave to do so. So I don't see this as comprising any violation of the rules of natural justice. I think where it's in the interest of justice to hear viva voce evidence, it'll be heard.
We've had the laurels now for the darts. On what basis is it believed that in the real world of criminal litigation, bearing in mind the number of counsel who are sole practitioners and the number of very small Crown Attorney's offices in the province, that these rules are practicable? Do they have any air of reality about them? Would not minimum procedure requirements consistent with historically supportable notions of fairness have been wiser than these exhaustive and doubtless exhausting rules? Have the hours of work and the calendar conflict these rules will create been adequately considered? I'll give that to a judge.
I think that that's a significant point, but we no longer, unfortunately, can afford the luxury of the extended court time that it is required when these types of rules are not in place. I'm cognizant that the rules are going to impose a significant additional expense, particularly in small communities and small practices, but when you consider, on the other hand, the time it takes to hear all of this evidence viva voce, to examine issues that can be well set out on paper, unfortunately, something has to give, and the resources are such that they're necessary.
All right, Jocelyn, I'm going to give this one to you. In view of the fact that the process of raising a constitutional issue, including 11B, has now been rendered infinitely more complex than ever before, will the increased complexity not have the effect of making charter remedies inaccessible to unrepresented accused and or those accused persons who cannot afford the cost of having counsel prepare elaborate factums and other written material involving lengthy preparation and production costs? Now, just if I may just add on to that, you were in the Court of Appeal this week, as I recall you, with dealing with a case involving production of documents with regard to charter arguments.
everybody should just be aware that the appeal of Judge Borns' decision in Regina against Kootenai was argued on Thursday and Friday this week. The Court of Appeal reserved, so it may be that some further guidance with respect to applications pursuant to Section 24(2) of the Charter to exclude evidence may be forthcoming from the Court of Appeal. Those applications are not dealt with by these rules, and so anything coming from the Court of Appeal will be in addition to what's in here. I don't agree that the requirements for bringing applications, such as ask-off applications set out from these rules, are unreasonable or render charter relief inaccessible to persons whose rights have been infringed. The requirement, for example, in the ask-off applications that all transcripts of previous appearances be filed is something that it's my understanding is currently in existence in most jurisdictions in any event. I don't see how an appropriate determination of that issue is possible without that evidentiary foundation being before the court. It's my view that problems with how much time it takes counsel to put something together are not an appropriate excuse for failing to provide the court with the information it needs to justly determine the merits of an application. And I don't think that these rules will have a dampening effect on the ability of deserving persons to bring forward those kinds of applications.
We're over our allotted time. I'll just take one more. This one's addressed to me. What is the effect of defense counsel changing his or her position after the pretrial conference? Is the accused, for example, stopped from contesting the admissibility of a statement when a voir dire has been waived at the pretrial? I think the simple answer to that is at the front of the form, the long form, it says this: the positions herein are tentative. All agreements are without prejudice and purely for the assistance of the court in the resolution of trial problems. If any change becomes necessary, counsel will endeavor to advise each other and the court promptly. It's, for the want of a better phrase, a without prejudice pretrial hearing. Thank you very much for coming, your attention. Thank you.